All right, this is the January 20th, 2022 meeting of the Informal Hearing Subcommittee of the Peace Officer Standards and Training Commission. These are informal hearings, and let's see, we will begin with Tennessee Department of Safety in the matter of Isaiah T.D. Lloyd. Is the Department of Safety here?
Yes, sir.
Okay, and is Mr. Lloyd here?
Yes, sir.
Okay, and Mr. Lloyd has counsel, is that correct?
That's correct, sir. Bryant Kroll here on behalf of Mr. Lloyd.
Thank you, Mr. Kroll. Ms. Cooper, Ms. Kim Cooper, do you have anything procedurally? If you could update the committee procedurally where we are with this particular case.
Mr. Floyd's matter has already been before the Informal Commission at least once before, and at that time it was recommended to go to the full commission for a hearing. In the interim, actually I think it was a default, and he received notice of the default and appealed. And so in the interim, Mr. Kroll and I have discussed the matter and agreed to present to the commission a proposed settlement. It went before the full commission. I think it was back in October. There were some questions regarding the terms of the settlement, and it was proposed that it go back to the informal committee for the informal committee to hear again, excuse me, the proposed settlement and to make the decision at that point. So this is something that, as I said, Mr. Kroll and I discussed, and I'm going to let him kind of present the settlement options on behalf of his client.
Yes, thank you. Thank you for having us here. I've got, and correct me if I'm wrong, Ms. Cooper, but I believe what we discussed was that this be changed, that his status be changed to retroactive 2-year suspension. And then that would enable him to get hired on with another agency in the future if he so chooses. And let's see. I think that's really all we're asking for here. Of course, if the committee has other thoughts about how to handle this issue, we're all ears. But we believe that that's fair and it's easy for everyone to do. So I think that's the most expedient option for this committee.
Council, you submitted a letter to the post commission. I believe commission members, there may be one in the attachment, the letter from the attorney explaining a summary of the minute. I so give them a moment to maybe review that, and they can ask questions if you have it.
Sure. And yeah, we put this in writing mostly because I think it was one of these hearings that there were questions raised about what our response would be. And as I stated in our letter, Mr. Lloyd is available to testify to any of these matters if the committee chooses.
Ms. Cooper, this is Commissioner Rice.
Yes, sir.
Can you go through with me again so I make sure I understand what we've done with this case so far? I know it's been informal.
Yes, sir.
We had a failure of service. We didn't do a proper service with the default. That's why it was kind of remanded back to us, I think, at the time. And that was why we had done a default because we thought he would serve notice, but he had not received that properly. And when it was approved by the subcommittee, it then went on to rec as a default. And then they came back and negotiated, and the full committee said, take it back to informal. That's kind of why we're back here. And they're basically presenting a 2-year settlement, a 2-year suspension as a settlement offer in this matter between the parties. Is that correct, Cooper? Attorney Cooper, is that?
It is, yes. It was a default. And so he actually has not appeared. Mr. Lloyd has not appeared before the commission before in order to present his side of events. And so it was, like I said, referred for, we would just have a hearing or we could settle the matter with this proposed settlement.
Yeah, if you choose not to take the settlement, it would be, you could then take whatever action and go to a formal hearing if that's what you so choose. And that matter would be up before the full commission. We have 5 members today. So is everybody voting? Is this kind of where you're? Just 3. Okay, you're just observing. Okay.
Mr. Knoll, this is Chairman Parton. Can I ask you a question, sir?
Sure.
How did y'all come up with a 2-year suspension settlement?
Well, it had been 2 years since then, or over 2 years. And I'm trying to think if there was a specific reason for that other than time's passed and we can avoid the need for a full hearing and all these things since, I mean, he's not trying to get reinstatement to the THP or anything. I don't think he has any desire to go back there at all. This is just about freeing up his ability to go to another department if he chooses. And this would also avoid all of the due process issues that have arisen because of the default. And I think it just saves time. So the number is easy. He's agreed to it. And I believe that's it. Is that right, Ms. Cooper? 2 years?
It was the length of time, correct, since he had been, I think since he had been terminated. And so it would, as he just said, it would resolve it from this day forward and free up the matter, so to speak.
What is Mr. Lloyd currently doing?
He's a nuclear welder for one of these nuclear, I guess, plants. He does, well, that's all I really know about nuclear welding. I'm certainly not an expert on it.
That's a good answer. Good answer.
I'll put that's above my pay grade there, but I'll state that he has had 0 disciplinary issues at his current job.
But this would be resulting in the case that's filed would show a 2-year suspension agreement, and the order would be in there for anybody looking to hire him.
What was the initial? When did he? What was the actual date? I don't want to zoom back through here, but Ms. Cooper, what was his actual resignation date from safety? When did he resign from safety?
He resigned. I was just looking that up myself because I didn't see it in the letter. Let me pull it up on a CADIS here. There he is. It says resigned in lieu of termination 10/11/2018. So actually more than 2 years. And because his length of the break in his service, he would have to go through transition school should he be hired.
I would suggest that if this is agreed upon, that he would need to go to a transition school based off what, by his own admissions, by his counsel about lack of training and this and that. I think that if he was to hire, I don't know how you would want to go from nuclear welding back to law enforcement. I'm sure there's a lot better pay in nuclear welding. But I think that most definitely some retraining, transition school would do him a lot of good. It just, from what I'm reading, it seems like he's one of those guys that is naturally attracted to issues. I'm just open for suggestions.
Mr. Chair, are the members of the THP, Department of Safety, are they here on this case or another one?
They're here for the next one, but I don't know if they're available. If they're here, I don't know if they'd be
I
able to
didn't know if
discuss it.
we needed to allow them to express what they would like to share
I
with
mean, they
us.
did the first time, and that's
Yeah.
what kind of happened. So forth. But if you'd like to rehear it, I don't know.
If he wants to contribute anything, I'd like
Do you have
to
any
hear.
information about Officer Isaiah Lloyd?
Just the same information that we presented the first time. If you guys want to go back through that, I can detail every case, the 9 investigations that were led to his termination. And again, it's up to you. You guys want to,
Was his supervisors also terminated during that time or punished during that? Do you recall?
not to my knowledge. I know there was some issues, a lot of in that district, but I don't think,
Was this a Knox
yes, sir.
district?
And a lot of people since then have retired. We've got a new chief of staff, a new commissioner. Captain Brooks, who were a part of his investigation, has retired, and Captain Bellhorn, who were on others, have just recently retired.
Would you care to identify yourself just for the record?
Sergeant Toby Carter, Department of Safety Office of Special Accountability.
Thank you, Sergeant.
Yes, sir.
I don't need to go, I've read all of it.
Right, I just say,
I wanted to afford them the opportunity to express any thoughts they had on it. It was investigated, he was
well,
a member of their department, and,
I'm just gonna say a formal hearing does not sound as the best option. Just maybe because pulling people out of retirement to come testify would not be the easiest situation in the matter.
No,
But we could do it.
I've read it all, and I don't need to rehash it. I just wanted to afford them the opportunity if they wanted to speak to this settlement or anything else that they feel like we need to know. If they don't, that's okay too.
I make a motion that we accept the settlement offer with the caveat that if he is looked at in being rehired in the state of Tennessee, that he must attend transition school.
Due to the 3-year break in service. that would be
Well,
right. But I want to make sure you put.
I want to make sure in this legal tender here, because they're showing 2 years, and I don't want that to be confused that his resignation date was in October 11th of 18, which I just don't want any legal issues coming back saying, well, y'all said this or said that, and so forth and so on. But that would be my motion.
I can make that clear in any order that's drafted. Yes, sir.
Well, we need a second first, and then they vote on it, and then, yes, the full commission they'll be recommended if it's passed.
Is there a second?
Well, that's why I kind of wanted to hear from them, but they don't have any thoughts on it. Then I'll second it.
Okay. The motion is to accept the agreement with the addition of transition school being a requirement for Mr. Lloyd is allowed to go back into law enforcement. Is there any discussion? Like I said, this is a very lengthy, lot of information provided by Department of Safety and very informative and a good job. I just, in this case, it's some procedural things, and I haven't, this gentleman's, I hadn't seen anything where in my brief overview, I hadn't seen any law violations of Tennessee code annotated, and but granted, Mr. Lloyd is attracted to. He's one of those magnets. It looks like, and
I believe it's pretty obvious that any department's gonna see what we're seeing. They'll be
right,
taking on that
and
responsibility.
if he is looked at to be hired or go into a department in Tennessee, then there'll be some retraining, and he and potentially having to come before us for waivers and that kind of thing in the future. So that's why I based off accepting the waiver or the agreement and move on. I'm done with my discussion.
Is there any other discussion or questions?
All in favor?
Any opposed? Hearing none, that passes. Mr. Kroll, what will happen in that case is that the subcommittee is going to be recommending this to the full committee, and the full commission will have to vote on that as to whether or not to accept that recommendation from the subcommittee.
Is that something that we'll need to be present for?
No, sir. We usually don't present that. It should happen tomorrow morning during the early part of the meeting.
Okay, great. Thank you.
Okay. The matter of William A. Matsunaga with the Tennessee Department of Safety. We do have notice on Mr. Matsunaga, Tennessee, and I believe he's present. Tennessee Department of Safety, if you would, and if you wouldn't mind to identify yourself for purposes of the record.
Sergeant Harold Stewart with Department of Safety and Homeland Security's Office of Professional Accountability.
All right, proceed if you would, sir, and just let us know.
Sergeant Shannon Brinkley was assigned this case, and essentially what happened was back in February of 2019, Mr. Matsunaga, who was a sergeant at the time, was posted a ad on a website trying to sell what was believed to be departmental ammunition. The Tennessee Bureau of Investigation, in conjunction with the Criminal Investigation Division with the Department of Safety, conducted an undercover buy and purchased the ammunition, and it was found that the 357 SIG ammunition that the department was using at the time, the boxes that he sold, the 5 boxes he sold, had the same lot numbers as department issued ammunition, and he was subsequently terminated for that. He was, the case was presented to a Sumner County grand jury, and indictment was returned for theft under misdemeanor theft, I believe it was theft under theft under 1,000. So the charges were subsequently dismissed later on in court.
Misters, do you have any questions?
How did, Commissioner Ryan, how did the department receive the complaint or notice about it?
I believe it came in through the Criminal Investigation Division, but I don't have that. I don't have that answer.
Has this matter been resolved according to the civil service or employment records of the department?
It went through all 3 steps of the appeal process, all 3 steps were open. Yes.
Commissioners, do you have any further questions for the sergeant? Thank you, sir. Mr. Matsunaga, would you like to address the committee?
Yes, please. My name is William Matsunaga. So this is my first time ever coming to a hearing of this kind. So when I thought informal, I thought I was gonna be a few people sitting at a desk and discuss this matter. I didn't realize it would be this crowd. So I have some questions if I can ask. So as a result of the informal hearing, what would be the most likely outcomes or possibilities?
Well, the informal commission will kind of decide this matter and make a recommendation to the full committee, who will be then tomorrow be reported to them at the beginning of the meeting. And they usually vote to adopt or so forth, or not. And that depends on what was actually taken today. I don't know. This previous matter was recommended for agreed order. That'll be presented tomorrow morning. And to recommend to the full commission, they can either not accept it or alter other action. So we usually take action that the commission usually takes is either to recommend a formal hearing. They can also do default hearings of revocation. They can recommend suspension. They can recommend dismissal. They have. So currently they still have not yet made any decision at this time.
So not knowing what to expect, I did write a statement. I'd be glad to read to you. It's kind of lengthy, and I don't know if that's the appropriate place for an informal hearing or not. I really don't fully understand.
Well, today's more of a preponderance of the evidence. They are going to take the matters, what is weighted more likely or not. Then at that point, it's not a formal court. You're not sworn in. If you'd like to read your statement, you're welcome to.
I think a preponderance of evidence will be more apparent, I think, based on my statement then. I'll be happy to answer any questions before or after. If anyone has any right now, I'll be glad to answer.
I think so. It'll be part of the record.
Commissioner Wright, I have one. Notice that Sheriff stepped out. We got, who's filling in for the alternate for him?
Don't know.
Before we got 2D.
We'll address a couple things while we're waiting. Some of the things they said is not in my statement. They mentioned lot numbers.
Mr. Matsunaga,
Yes.
I would suggest that you wait on them to come back. And then you can, that way everybody gets to hear everything you've got to say.
One of the commission members, would you be able to step in to participate?
You have to have.
You go ahead. Seniority prevails.
Stepped out, probably with a call or something.
We would make sure we have odd number. We have 5 commission members, but 2 are observing.
Okay.
And so we try to keep odd numbers so you don't have a tie if things get locked in. So we have commissioner member here will substitute for the chairman.
This is Commissioner Bobby Wagner, I'm alternate to this committee.
You may proceed now.
Okay. So I'll address a couple of things real quickly based on what I remember them saying. And the key point in this was the lot numbers. Now, as
most people know there's a serial number on a handgun. The serial number identifies that handgun, who made it, and if there's records kept, who bought and sold it, who sold it, and then who bought it. A lot number, which is assigned to ammunition, assigned to lettuce in the grocery store, assigned to the cereal boxes. A lot number is for quality control. That's a big difference. That's the basis of the state's evidence against me, is that the lot numbers, some of which are the same as lot numbers they bought. Well, there's a couple of aspects to that that are important. One, I could have bought those same lot numbers as they bought. So could anyone sitting in here could have bought, if they bought the same ammunition, they could have bought some from that same batch. A lot number does not identify a bullet, does not identify anyone who bought or sold it. A lot number only identifies the batch. If a manufacturer makes 10,000 bullets, they'll assign it a lot number. If someone is having jams, they can call the manufacturer, they'll say, what's the lot number? So I've done this myself with other ammunition. So what's the lot number? Well, I don't have the box anymore. They said, well, you don't have the lot number, you don't know if that's a defective bullet or a batch. If it was a defective batch, then they said they would reimburse me, for my ammunition. So lot numbers don't identify the bullets. During their questioning, I was perplexed because I thought maybe the ammunition they were referring to had some kind of marking on the actual casing. Manufacturers have markings on casings. I thought maybe theirs was different. So I was confused, because how could they say these bullets belong to the state if there's no, no markings on the casings themselves other than what's on all the other ones? So the bullets that I sold were my bullets, looked like anybody else's bullets, and so that lacked any amount of truth, and that was a huge reason why the DA saw there was no merit in this case, dismissed it, because there's no way of proving those bullets belong to anybody, state, me, or anybody else. The lot numbers do not prove that. Secondly, during my internal affairs investigation, I told them, when I come to the gun range, I have a lot of bullets at home in various places, and transporting to the gun range and home or to a private gun range, boxes tend to get torn and weathered a little bit. So I have boxes at home that might say 9mm, and I have 40 caliber bullets inside of them, just because that box is in better shape. Other boxes falling apart, where they got wet, torn. Maybe I empty the boxes and fill the magazines, threw the box away. When I come back, I didn't shoot all my bullets. Now I got a bunch of loose bullets. And in my storage, I have a couple of Ziploc bags of just loose bullets in them. I don't have the box anymore. It was bad, or I'll throw it away. So when I go to the gun range, I would just grab some empty boxes, because they were brand new and in excellent shape. And I would put bullets inside, boxes that the bullets didn't come from. Whether it's the same caliber, the same lot number, doesn't make any difference. I just wanted a good box. And in the pictures they took, you can see inside a box of bullets, there's a little plastic tray. Some trays are white, some trays are black. I don't know which tray came from which box or which one. I put bullets in a tray, put them in a box. So whether there was lot numbers that I bought or boxes that I swapped around, which I told them this from the very get-go, I moved boxes around, and they came to my house, and I showed them how I stored my ammunition, and they saw that, and they took pictures. But none of that ever came up. They didn't use any information they found that was in my favor. They only used information that they wanted to use. I'll read my statement if you don't have any questions. Okay. So I understand pursuant to Post Rule 1110-2-042A that by post certification can be suspended or revoked for any of the rules 1 through 6. It's my understanding that Rule 3 is a cause for matter being brought before the commission, as I was discharged for disciplinary reasons by my now former employer. While there is no question I was discharged by my former employer, when they state it was for disciplinary reasons, I rebuked that position. I was discharged due to the political power of one person inside the Tennessee Highway Patrol. I did not violate any state or federal laws. I did not violate any state policies. I did not even violate any agency general orders. And there is zero proof I did anything wrong. I've adamantly denied their accusations that I sold property that was owned by the state. On this topic, this is important. There was no lawful reason for me to be singled out in this manner. The fact is, I was singled out and investigated because I was politically unpopular to an influential political figure. I was aware I was unpopular at the time, and it was apparent because of how I was being treated over the past year of my career. In hindsight, I should have just sat back, not been seen or heard from for a year or so until the powers to be got over being angry at me. Had I been more submissive or kissed the ring of the powers to be, I would not be here today. But all I did was apply for a transfer to another division. That was not a reason to take offense at my existence. I was aware there would be a risk of retribution if I applied for anything, but I did not see that going this far. But to understand what I'm saying here, I have to discuss a couple of things that took place earlier that built up to this. There's a backstory to my current woes with the THP. And the backstory is the reason why I was singled out and fired. I'm here because I pissed off my politics. It's just that plain and simple. Just a short time ago, I was a lieutenant on Foster Avenue in a cushy office job. I was being groomed to be the captain over the RP&D unit. While I never wanted the lieutenant position there, I was talked into applying for that job by then Major Matt Perry. You might know him as Colonel Matt Perry. But that was over a year ahead of him. He is a masterful politician, and he was putting me in this place to serve as his policy guru once he became colonel. But I did not see the future that way. I wanted to work the road, not an admin job. He knew that, but he continued to pursue me to apply for the RP&D opening. Eventually, he told me in confidence that all I had to do was apply and show up at the interview, and the job was mine. The fix was in, as he had already had the second vote in place of the 3 interviewers. Obviously, the others who interviewed had no idea that the interview was fixed. When I took the job, Matt Perry told me not to do anything stupid, because he was not the only one who had to stick his neck out to get me promoted. Referring to then Lieutenant Colonel John Albertson, who was the other prearranged vote. By sticking his neck out, he meant Colonel Crazy Trot did not like me, did not want me in that key position. I was in the position for over 11 months and all was well until a problem with my next door neighbor got worse. I got into an off-duty parking dispute with my next door neighbor. She complained to everyone and got nowhere. So she went to the media. The media did a negative one-sided story against me a week prior to my probationary period ending. Matt Perry ensured the internal affairs investigation was done in a couple days, the fastest I've ever seen. And I was demoted back to sergeant on the last day of my probationary period. The entire investigative process took a couple days. Historically, they often take weeks or longer to conduct investigations. The only reason to fly through this investigation was to finish it and demote me while I was still on probation. I had no ability to appeal. And that's just what happened. While I did not violate any policy or law, they used a catch-all unprofessional conduct to demote me. Almost anything can be considered unprofessional conduct. It's completely subjective. The THP makes that determination as they see fit. So here was where I pissed my politics off. The parking incident that went to the media. Matt Perry clearly got chewed out by Colonel Tracy Trott when the news story came out. So when the parking story hit the news, Perry got reamed, and as you know, that rolled downhill to me. Perry was furious with me which was substantial because I've never seen him angry before. And we'd been something of buddies up to that point. And unfortunately, I did not kiss his ring to ask for forgiveness. I stood my ground over the parking incident because of principle. But there was little room for principle on Foster Avenue, only politics. I was quickly demoted and transferred back to the road. While happy to be back on the road, it was demeaning to be demoted. And since I was demoted for something so unimportant, I felt betrayed. Matt Perry dealt with me too harshly over the parking incident, and I lost respect and loyalty to him. Thus, I began letting people know how Perry had arranged for my promotion in advance. And I'm sure my big mouth also played a big role in burning the bridge with Matt Perry. So it was no surprise that he was looking for a reason to get rid of me, even though he never got in trouble for rigging the interviews. Who would dare say anything cross about someone so influential? Plus, it's common knowledge to say that many interviews are fixed in THP. It's still a good old boy system. It's not as bad as it once was. Time passed and Colonel Trott retired. Shortly later, I applied for another lieutenant position, but one on the road as I originally preferred. I hope that Trott gone, Perry and the rest of the command staff would not be as hard on me. This is when I learned it was too soon and I was still in the doghouse. After I applied for promotion, the THP reopened an old investigation related to me from months prior, where another trooper allowed a prisoner to escape. During this investigation, I was given a 2-day suspension despite giving the search for the escapee everything I had. I was not present and played no role in the escape, but I was punished for it. The timing of the newly reopened investigation was not coincidental. It was reopened because I applied for a promotion that was used as justification to prevent me from getting the position. Furthermore, the person they wanted had a father who had been a THP lieutenant a few administrations ago. You can call it politics, nepotism, or the good old boy system, but it is what it is. Regardless of whom they selected, the THP violated Tennessee law by not violating it. Violation was based on the fact that I'm a military veteran, and the TEAM Act required them to interview me and give me preference over a non-veteran, which he was not. The newly reopened investigation did not provide an exception to the law. It was just what they did. They could have interviewed me and then passed me over if HR allowed it. Since I was far more qualified than the other person, I guess they had to keep me out of the interview any way they could. I could go on about this, but the point is that the THP will obey rules and law, or not, as they see fit. And that does not just apply to me. The interview I had applied for was a good location, and the 2 other sergeants applied for the same position. 2 of the other sergeants had internal affairs cases opened against them after they applied for the same position. I don't know the details of those cases, but my understanding is those 2 troopers also saw the coincidence of the timeliness of everything. Politics is a good thing when it's on your side, but not so much when you're on the wrong side of the stick. I want to qualify this as I had no idea that Trooper Lloyd was involved in this project before it was going to be heard today. It was a surprise to me when I heard that this morning. Here's an example where the same trooper was on both ends of the stick after a massive media intervention. In August 2017, former THP trooper Isaiah Lloyd was accused of improperly touching a female driver twice on the same day, 2 different traffic stops. Colonel Tracy Trott gave a media statement stating that Trooper Lloyd was cleared of any wrongdoing. After the female driver filed a lawsuit in 2018 and continued to complain to the media, the THP reopened the investigation. He no longer works there. The THP would do whatever it wants when it wants. That is politics. Some months went by, I saw there was an opening for an investigator position. It was not a promotion, so I hoped that they would not find a reason to punish me. I assumed it would be a risk, but I had not done anything wrong to get investigated for, so I applied. I was interviewed. And I'm mostly certain I was going to be selected by the group who did the interview. The other two candidates were not selected, so it had to be me. I was not advised right away, and usually the candidate knows at the end of the day. Some time passed and I learned why. Apparently, when they saw I was interviewing for this position, they searched everything to find anything they could use against me. That's what they did. Around the same time I applied for the transfer, I posted a sale of personally owned ammunition on a website called armslist.com. I was a registered user of this website, and I have used it many times over the years to buy and sell guns and ammo. There was absolutely nothing illegal against policy in selling a gun or ammunition. I did not plan to sell it while on duty or represent the THP in any way. The ammunition I sold was personally owned and perfectly lawful for anyone in the public to have. It is sold on several websites that don't even require proof of being 21 years of age, let alone having a police affiliation. The manufacturer may require it for sales on their own website, but even if they do, that does not apply to resellers. I use the same marketing tactics as the manufacturer in my listing. I was not selling the ammo to make a profit, only to break even. I did not like that particular ammo, and I wanted to make sure wanted to make space for ammo for a new 45 I just purchased. The THP arranged for an officer from another part of the state to come to Hendersonville and buy the ammo. I met the individual and sold my personally owned ammo to him. I had a hunch he was a cop as well, but the only thing that was odd about the sale was that he said, if I get any more in the future, let him know. This was odd, because my listing was very clear that I was clearing out this ammo. I thought to myself, why would I buy more ammo and then sell it for less? We went our separate ways, and a couple of days later, I was called to our CID office where I was read my Miranda rights. I was totally dumbfounded. I openly admitted I listed and sold this ammo. It was my ammo, and it was completely lawful to do so. I was told I was being investigated for the illegal act of selling state property. I was always clear that this ammo was my ammo and not state property. And I had no way to obtain 5 boxes of state-owned ammo. Where would I get it? Why would I do that 20 years into my career? I assumed it was such a law, and after being decommissioned, I went home to research. It turns out I was being investigated for something that was not even against the law. I looked and looked, there is no law that prevents someone from selling state-owned property. There are laws about surplus property and such things, but nothing related to what I was being accused of. I don't know when they figured it out, but there was always something. No matter what, you can always find something to charge someone if you really want to. That's what they did. While there was no accusation or questioning about my having stolen the ammo from the THP, there was a loophole that let them charge me with theft, and that the wording of the law mentioned something about controlling or selling something that the person did not rightfully own. That clause allowed the THP to then charge me with a misdemeanor theft, and thereby everything they needed to justify firing me. There was no proof that the ammo was theirs, and I consistently denied it being theirs. I was fired for unprofessional conduct based solely on the otherwise lawful sale of ammo. They also stated I failed to do a background check of the person selling the ammo. The only licensed gun dealers are required to do a background check on someone buying firearms, not ammunition. I had no obligation to do a background check. And if I used my position to have done one, that would have been against the law. They were scratching at carriers to justify my termination. Every cop and most civilians know you don't do background checks for ammo sales, and private parties don't even do one for guns either. But this was one of the reasons to terminate me as well. The THP tried to amp up even more charges and attempted to have me charged with felony theft and official misconduct, both felonies. I don't know what nonsense they used to try to justify those 2 felony charges. But they were only able to eke out a misdemeanor theft charge against me. But that's all they needed. I guess they aimed high, hoping to get something out of it. I would love to know what they said while trying to charge me with these things. I can go on and on about the weaknesses of their case, but there was one primary goal achieved as a result of charging me with the crime. I appealed my termination, hired a lawyer for the appeal, another lawyer for the criminal charge. The criminal charge kept getting pushed back at the state's request because the THP continued to bring new evidence that the DA and my attorney had not seen. That's key. Months went by, then my trial appeal took place. My lawyer, who was not prepared for what he called a stacked case against me, was caught off guard. But the primary reason why I lost my appeal, and the panel discusses the case in my presence, so I know, was that I had a pending criminal case against me. Because the THP had the criminal case reset twice, it was still pending during the trial appeal hearing, and I lost based on this clause for the good of the service. Remember, with an active criminal charge is not good for the service. When you work for a normal employer, they can fire you. They can try to have you arrested, and sometimes they can do both. But when you work with THP, they can certainly do both. And since they've lost a number of job appeals, they've learned some tricks. They told my life and my livelihood over something that was never proven and not true. It was just dirty politics. So that was the worst outcome that resulted from charging me with theft and postponing the case several months. I lost my job appeal. The worst outcome wasn't getting arrested. The worst outcome was losing my job appeal because they postponed the criminal charge a couple times. I would have won that appeal. We would not be discussing and would not have been dismissed for disciplinary reasons if it were not for the dirty politics of THP. They did not need a solid criminal charge. They only needed to get something and then drag it out until after my trial appeal was over. All these accusations against me derive from one person inside the Tennessee Highway Patrol who devised a narrative and ensured that subsequent investigation justified that narrative. Essentially, one person had an agenda to demonize me and took advantage of his political might to take a completely innocent and lawful action and twist it into the false narrative which was used to discharge me from employment and have me arrested. That is real political might. They succeeded in firing me, as they were the judge and jury on that topic. They succeeded in fighting my job appeal because they wrongfully charged me and then delayed the court hearings until after the job appeal hearing. This is why I'm here to protest the suspension of my post certificate. I was not discharged for disciplinary reasons. I was discharged because Colonel Matt Perry wanted me out. He had the clout to make it so. That's politics. Actually, it's more than that. I consider Perry's involvement in this case official oppression, which is a E felony in Tennessee. My criminal case, I pled not guilty. Eventually, the DA over this case was able to see it lacked merit. The charge was dismissed and has been expunged from record. I should have sued, but I just want to move on with my life. Clear my name and move on. I only ask for some consideration here as it applies to Rule 3, since my dismissal was based largely upon politics, not tangible evidence that truly justifies disciplinary reasons. Thank you.
Questions from the commissioners?
Commissioner Wright, how, I know you do not know, I know that you probably know, so how do you think that this got reported to the Highway Patrol?
Well, as I alluded to during my statement, is when I applied for the transfer, I knew my name was gonna come out into the Foster Avenue halls. And it was my belief that some individuals looked for anything they could, whether they scoured the internet, talked to people, I don't know. yes, my posting on arms list is, I'm registered as an arms list user. My phone number's on there. Maybe they Google my phone number. That's all I had that posted. That was a completely lawful sale. There was no reason for a police agency to do a huge covert investigation over a handgun sale or ammunition sale. They weren't missing ammunition. They never said, hey, we're missing 5 boxes of ammunition. Where'd you get this from? Or, you know, we have video camera evidence of someone sneaking in our armory, which I don't even know where the ammunition's kept. They had no reason to investigate me. I was singled out.
How many times have you sold ammunition on the internet prior to this?
That's probably my second time.
Same caliber?
No.
What was the other ammunition sold?
Probably 40 caliber. I don't even have a 40 caliber. I have one 40 caliber pistol that was a cheese piece. My initial handgun highway patrol was a 40 caliber. The Smith & Wesson Sigma. Wasn't very popular then, so I do own one. So I have a few bullets for that, but I did have 2 40 calibers years ago. When I went down to the one, which I don't even like that much, other than it for the significance of that was my first issued handgun. So I sold some of the 40 caliber ones. I sold my 40 caliber gun and bullets.
Did you have any evidence where you had bought the 357 SIG ammunition that you sold?
No, I bought that ammunition years ago. When Highway Patrol had switched from 40 caliber to SIG, they were using Remington Golden Saber, I think. So I bought a case of that because they want you to carry the same ammunition. If you're off duty, you can carry your work gun or your private owned gun, but you can't shoot your own. You shouldn't shoot your own personally owned ammunition. I would think in a state owned handgun. If you're going to carry a state owned handgun, you should carry the same kind of ammunition you train with. So at home, I have a case of Remington Golden Saber still. When they switched from Golden Saber to Spear Go Dot, I bought another case of that. But I don't have records of any of my bullets because bullets are a commodity. You buy them, you shoot them, and you're done. Unlike a handgun with its records kept, I have all my receipts for my handguns. Even when I sold them on arms list, I'd write out a bill of sale for a handgun because that's something with the serial number that can be identified. And so I'll always make sure handgun sales have a bill of sale with my ammunition. I wouldn't keep that no more than I would groceries from Kroger. Lot number or not, that's ammunition's not.
Well, my thought was you may have put it on a credit card, not prior to that, you stated that you bought it, didn't like it, was trying to resell it or whatever at that point, but, I forgot what my next question was. Anybody else got one? No, go ahead. Let me think of some more, man.
Commissioner Parton, during this investigation, and I might have missed this somewhere, did, when you were being investigated on the criminal matter, were you ever offered, or did you ever take a polygraph?
No, and I wish Highway Patrol had that luxury too. And in playing this back in my head, I know why they didn't give me a polygraph, because had it come back in my favor, then what would they do? They're not gonna fire me if I pass a polygraph. So they chose not to pass a polygraph. That was their decision.
You said you had an attorney retained, you had an attorney representing you?
I did.
Did he offer to take and have a private polygraph done?
You never mentioned that.
I make a motion to forward this over to the full formal hearing.
I'll second it, because I believe we can sit here and debate. We're pretty much gonna be going that direction anyway.
Right.
I'll second that motion.
Okay, the motion on the floor is to recommend this up to the full commission. Is there any discussion? Hearing no discussion, all those in favor, say aye.
Aye.
All opposed?
So what happens now is this will be presented tomorrow to the full commission, So the subcommittee recommends that you would appear, the THP would appear for a formal hearing where it would be evidence, where you'd be sworn in, matters would be taken, and testimony and witnesses would be called. You could bring your own witnesses, and also you could cross-examine THP's witnesses and so forth. So it'll be more of a formal hearing. And to that time, there's no action against your certification. It is still active, or it's inactive, but it's still effective. Until that hearing is scheduled and the matter is determined before the full commission to hear, before ALJ judge and the voting of the full commission to determine what action if it need to be taken. Does that answer your question, proceeding?
Yes, sir.
So if you do wish to present counsel, we will be in touch, counsel for the commission will be in touch with you. Please make sure your address is up to date so that you can participate in the hearing. We'd like to make sure that is done and scheduled at a future date. And then like I said, we will go through the procedures of how that is done. You may represent counsel, you may represent yourself, but it will be done more formal in that regard. It will be a judge with a formal order, scheduling and so forth, and evidence and witnesses and so forth. So, and, any questions regarding that?
So at the conclusion of the formal hearing, it would either be,
The full commissioner would make a vote of what action to take that day. Today, they're just saying, we don't have enough information. It just formal, the whole board would be better satisfied to hear you, ask questions, talk to witnesses, hear the evidence, and make a decision.
then at the conclusion of the formal hearing, it would either be to revoke, suspend,
Dismiss or other, and then there's a point where if both parties have decided to appeal, at that point, we would appeal to the full commission for reconsideration. If that's not done, then you're right to appeal to Chancery Court, and that would go to take the decision up there. So
what timeline are we looking at with this?
I don't know yet what timeline we're. It'll be a few months because we already had a formal schedule for March and so forth. So, you're currently working as,
Construction fee.
but this has been, we don't like them pending too long. If you're available to schedule and go forth, we can tend to move things faster. As long as your information is updated in the system. Okay. We will be in touch. Like I said, that'll be it. Thank you.
Thank you, sir. All right, this concludes our hearing. Ms. Investigator Cooper, if you don't mind.
We will be meeting tomorrow at 9:30. Full commission meeting.